Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to the viewers of Islamic Finance Today program at Capital TV, the only Islamic finance program in the mainstream media. And in this episode, Islamic Finance Today will introduce the viewers of Capital TV to Kuala Lumpur Regional Centre for Arbitration, KLRCA. The Kuala Lumpur Regional Centre for Arbitration was established in 1978 under auspices of the Asian African Legal Consultative Organisation, AALCO. KLRCA was the first regional centre established by AALCO in Asia to provide institutional support as a neutral and independent venue for the conduct of domestic and international arbitration proceedings in Asia. KLRCA is a non-profit, non-governmental international arbitral institution and is administered by a director under the supervision of the Secretary General of ALCO. While it is fully funded by the Government of Malaysia under a host country agreement with ALCO, the centre has been accorded independent and certain privileges and immunities for the purposes of executing its functions as an international organisation. KLRCA adopts the United Nations Commission on International Trade Law, the UNCITRAL arbitration rules with modifications. That is the Islamic rules for arbitration of the Kuala Lumpur Regional Centre for Arbitration, KLRCA I-Rules. Let us view an interview with the Director of KLRCA, Datuk Sundra Rajoo.
KLRCA is actually an ALCO body, Asian African Legal Consultative Organisation. We are set up as a mission in Malaysia under a host country agreement with ALCO, where the Malaysian government supports us by providing the building and also facilities and finance. But other than that, we are independent. We are independent, and our logo, as you see, is KLRCA, is Kuala Lumpur Regional Centre for Arbitration, and we have a tagline called Regional Resolution, Global Solution, because this is what we do.
Right.
We solve problems regionally, but we implement it globally.
Right. And how long has the KLRCA been in existence?
We are the second oldest arbitral body in Asia after CTEC. We were founded in 1978. It's about 34 years. So we are one of the oldest.
And the premises have been here for 34 years?
No. We moved in here in the 90s.
Right.
And we are going to move to a new set of premises, which is going to be a world-class dispute resolution center at the Sulaiman building, near the old railway station.
Right. So this can be seen something like an all land shine kind of feature program before you move to your new premises.
It is a start. It is a start. It's not an all land shine. We have this center where we provide arbitral facilities. We have hearing rooms, we have breakout rooms, we have a library, and it's also where the center operates from. We have about 20 staff, different things. We have different. The center is divided into case management. We have in case management there are two parts: the dispute resolution, arbitration part, and then we have the adjudication, because we are also the adjudication control authority under the new act called the Construction Industry Payment and Adjudication Act.
So do you have people just from Malaysia here, or you have people from overseas coming in as well?
We do have. At the present moment, we do have people coming in to work for short periods of time, interns, and at one time we had even overseas staff. The ambition that we have is eventually that some of our staff will be international staff to reflect the actual
global ambitions
work
that you have.
No, the actual work we are doing, because we are also doing work that is coming outside of Malaysia, while some majority of the work is from Malaysia. We are moving towards internationalization.
Right. So where do you see KLRCA being positioned regionally or globally in like 5 or 10 years time?
No, we want to be the preferred appointing authority, but preferred dispute resolution center in Asia. And what we intend to do is that offer our services, that basically that more and more foreign parties will come to Malaysia to arbitrate or to resolve their disputes through mediation or even adjudication. Adjudication is basically for the domestic market, but internationally arbitration is the thing. And it is a crowded market with Singapore, with Hong Kong, with London, with New York. But we have a lot of advantages that we want to actually provide.
So how do you differentiate KL and the arbitration done in Singapore or China and other places in Asia?
We differentiate it by a few methods. One is the products that we have. Our product, for example, you're holding the i-Arbitration rules. This is the first set of arbitration rules in the world which deals with Sharia compliant instruments, that means Sharia compliant contracts. So if you have issues of Sharia, this particular set of rules can deal with it. We have devised this thing. That's one. We have our general, our normal arbitration rules. We also have fast track rules for different segments. The other thing that we actually emphasize on is Kuala Lumpur itself. It's a cost-effective center in the sense that hotels, it's a hub. KLRCA is one of the finest airports in the world. You can land here, you can take a train, go straight to your hotel. Your hotel room is very reasonably priced, and then you can actually come to the arbitration center, do your arbitrations. We have a sound legal system. We have a vibrant legal profession. Lots of things that we can offer at a much more cost-effective rate than other centers.
I see. Right. So you're telling me that with regards to Sharia arbitration, Malaysia is the first country, not only in Asia, but in the world to introduce such.
Our rules at the present moment is the only set of rules we know which applies for international arbitration.
So will become the gold standard in that matter, isn't it?
I believe that once other people start to imitate these rules, then we know that this is the standard. So we have to wait for that. But at the present moment, we are translating this set of rules into Arabic, Indonesian, of course, and I'm also translating the main rules into Korean and Mandarin.
Korean and Mandarin.
Yeah, because our market is diverse.
I see.
And then, of course, when we go to India, English is good enough. So we are approaching, we are segmenting the markets also, and we are marketing to bring knowledge that there's such a set of rules that people can use, and you can arbitrate anywhere in the world. You can have the venue in India, but the seat can be in Kuala Lumpur.
Right. Thank you, Datuk, for your explanation. In the meantime, do you mind if you show me around?
Sure. This is also the section that does all the research and the papers and all the so we have Mr. J from Korea, and then last time we had people from China, Korea, India. And we had from Australia, so we do have international staff, and we continue to look for people who will help us. So I think we also have another section for adjudication, which is the new thing that we are going to do, where we have been doing a lot of training courses. We've been training adjudicators, and then it will be applicable in the construction industry.
In a nutshell, what's the difference between arbitration and adjudication?
Adjudication is a short but temporary process, rough justice, in the sense that the decision by the adjudicator must be made within, let's say, 95 days from the entire process, and his decision will be temporarily binding. But whereas arbitration, the decision is final. So of course, both are subject to appeal, but temporary binding, that is, your adjudication, after adjudication, you still can go to arbitration. Whereas arbitration, once it's done, you only can actually set aside the award or uphold, register the award. So it's a bit different process. One is final, one is temporary. But for the construction industry, adjudication has been brought in under the CIPA Act, which is the Construction Industry and Payment Adjudication Act 2012, last year, where it is intended for cash flow in the construction industry. And we have done a lot of training programs. We have 300 adjudicators now on our roster, and we intend to train more adjudicators We have asked the Minister of Works to decide on the date of implementation of the Act, and then we are ready to go.
Arbitration is not about going to the courts. So how does it work? All this when we come back. Welcome back to the Islamic Finance Today at the Capital. In this segment, Datuk Sundra Rajoo will explain about the KLRCA and arbitration rules. Arbitration is a less formal way for parties to resolve legal disputes outside of the court system. It aims to provide fair and unbiased resolution to disputes without causing needless delay or expenses. In arbitration, each party has the right to be represented by an attorney but may proceed without one. Rather than going to court, in arbitration, both parties present evidence to an arbitrator who follows the provisions of the arbitration agreement and the rules of the administrator when making a decision. Arbitrators are deemed judges and their rulings are equivalent to any judicial award. Let's watch what Datuk Sundra Rajoo says about KLRCA and arbitration rules.
Thank you, Datuk, for coming on board.
Thank you, Rajoo.
Let's get on the camel, so to speak. What is KLRCA all about?
KLRCA is an international body. It's a branch of the international body, ALCO, which is the Asian African Legal Consultative Organization, which is based in New Delhi. The Malaysian government entered into a host country agreement with ALCO to set up the regional center in Malaysia, in Kuala Lumpur. And it was the first regional center ever set up by ALCO in 1978. Since then, ALCO has set up a number of other regional centers, one in Tehran, the other one in Nairobi, one in Lagos, and another very successful one in Cairo. So the concept is a bit different. We are set up as a diplomatic mission, but we do ADR service provision.
Right, Datuk, when you say about arbitration, why do we need to have arbitration? Isn't the legal system that we have in Malaysia now sufficient?
Arbitration actually is for people who do business. When you do transnational business, you may not want to go to a national court. That means, let's say I am doing business with you and I'm based, let's say, in Indonesia, and I am buying something from you, I'm selling you something, but I don't want to go to a Malaysian court, neither do you want to come to an Indonesian court. So they will choose arbitration. The great advantage of arbitration, it is recognized internationally as the preferred dispute resolution mechanism, and the award can be enforced internationally because of the New York Convention.
Right. And what is the New York Convention?
The New York Convention is a treaty arrangement between, at the present moment, 147 countries have signed that, where they agree to enact a local law which recognizes foreign arbitration awards. So when you have a foreign arbitration awards, and if you are a signatory to the New York Convention, that foreign award, when it comes to, let's say for example, we have an award from England, it comes to here, the court will enforce it as a judgment.
As good as if it was done in Malaysia.
As good as it's done anywhere in the world, but it will be enforced in Malaysia. So the advantage for a businessman is that he can enforce a judgment he gets, the award that he gets, in any of the New York Convention countries. So I think, for example, we had the Celcom-Deutsche Telekom dispute. The award came out from Switzerland. It was never enforced in Malaysia. It was enforced in England, and then they wanted to enforce it in Singapore. So you can go around wherever there are assets and you can enforce it. So I think this is the modern way of doing business. And the other thing is that in certain industries, for example, construction, maritime, where there is highly technical, people prefer arbitration. So you find the standard form contracts like charter parties, construction contracts, they will have an arbitration clause where domestic parties themselves, parties, let's say two Malaysian parties, will arbitrate rather than go to court. Because when they go to court, they will get a judge who is schooled in the law but may not know about construction. So when they go to arbitration, they can get, let's say, an engineer who may be also trained in the law to hear construction cases. And the courts are sometimes very busy. They can only give you so many days to hear the case. Whereas when you go to an arbitrator, because you are paying him, you can ask for more days of hearing.
So in arbitration is only one of the methods under alternative dispute resolution. I believe you were saying earlier about adjudication.
Yes.
Right. What's the difference between arbitration and adjudication for that matter?
Arbitration is governed by the Arbitration Act 2005, and the award that comes out is final, and the court will enforce the award, and it is quite difficult to set the award aside. There are recognizable grounds under the Act and can only be set aside for let's say in excess of jurisdiction or lack of jurisdiction or in conflict with public policy where the law is very well defined. In the case of adjudication,